Good afternoon, everyone. My name is Deborah Hanlon, and I'm the Events Manager at the CICBV. I'd like to thank you for joining us for today's webinar, Deconstructing Transaction Agreements from Three Perspectives. Please make sure that you're logged into the web portion of the webinar to view the presentation slides at www.readytalk.com. You may notice that your telephone lines are muted, so if you have any questions for the presenters, please enter them in the chat box in the lower left-hand side of your screen. Feel free to send in your questions for the presenters throughout the presentation, as we will be addressing the questions throughout the presentation rather than just at the end. A copy of today's presentation slides will be sent to all registered participants at the conclusion of today's webinar. The presentation today is going to be approximately 2 hours in length, and that's going to allow us time to address questions during the presentation. I'd like to introduce our presenters today. First, we have Mr. Paris Aden. Paris is a partner and co-founder of Valitas Capital Partners. Paris has broad industry experience with a focus on the energy, materials, industrial, and consumer industries. Since 1994, he has been involved with more than 100 M&A transactions with an aggregate value in excess of $80 billion. He has advised clients at Morgan Stanley, Credit Suisse, and RBC Capital Markets, and has acted as a private equity investor at Clairvest Group, where he served on portfolio company boards. Paris is concurrently a lecturer at the Queen's School of Business in their Masters of Finance program, and is an instructor and facilitator for Moody's Analytics Advanced Capital Markets program for capital markets professionals as an M&A subject matter expert. Next, we have Jake Bullen. Jake is a partner at Castles Brock who practices in the business law group with an emphasis on mergers and acquisitions, public and private financings, corporate reorganizations, and complex commercial agreements. A significant portion of Jake's practice includes advising on cross-border matters, representing international buyers, sellers, investors, investees, lenders, and borrowers. He advises large U.S. and international companies on Canadian legal matters, including commercial agreements such as distribution agreements and vendor agreements, as well as corporate transactions such as M&A and financings, and general corporate advice such as cross-border structuring and corporate governance. Jake is the author of a number of articles, including recent legal changes affecting Canadian M&A and emerging issues in due diligence, which were published in Financier Worldwide. Jake is an active member of the Mergers and Acquisitions, Private Equity, and Venture Capital and International Business Law Committees of the American Bar Association. And the last person presenting today is Robin Weber. Robin joined Hub International in 2013 as an AVP with a focus on transactional liability and private equity insurance placements. She has over 4 years of experience in the executive liability sector of the insurance industry, and before joining insurance, worked in the investment and securities industry. She is currently the practice leader for private equity business at Hub International and manages placements in both the transactional liability insurance sector as well as private equity and portfolio company executive risk placements. She is actively involved in the Canadian Venture Capital Association. I'd like to thank very much Paris, Jake, and Robin for joining us today. You may begin your presentation.
Thanks, Deborah, for the kind introduction, and thank you all for joining us over your lunch hour if you're in the Eastern time zone, and to the rest of you who are joining us across the country. We are going to be talking with you today about transaction agreements from a business evaluator and financial advisor perspective. We're going to focus on those aspects of transaction agreements that people in our profession should know. It's geared towards people who have had at least some exposure to M&A, but not necessarily M&A experts. So for those of you in your valuation practice who have come across some M&A transactions and have worked on a few over the course of your careers, you'll get something out of this. And for those of you who do this more often, I think we have some other more in-depth information that will be useful to you as well. In terms of the person speaking, it's Paris Aden with Valitas. I'm going to just run through an agenda for you and describe who's going to go through each part of the presentation. I'm going to take you all through the case scenario, some opening comments, and an overview of advisor roles. And then Jake is going to take you through the transaction agreement structure, the Pegasus Corp situation update. That's the case study we're going to run through. Robin will have a discussion about 30 minutes on representation and warranty insurance. And then I'll come back around to discuss transaction costs and the impact on realized proceeds. Jake will talk about other recent developments on the legal front, and then I'll make some closing remarks. So in all, we expect that we'll be through the presentation portion in about 100 minutes. We will stop along the way for questions, and we expect we should be able to handle this within the 2-hour time frame. Deborah's already introduced us, so we're just providing here 3 different perspectives on the transaction agreements, and I think an interesting twist here is having Robin involved here with us today to talk about rep and warranty insurance and how it can be helpful in sorting through certain aspects of the transaction agreements. We thought it would be best to provide some concrete examples to go through some of these concepts. So we've constructed a case study. It'll take me about 15 minutes to run through some of the key facts, and then we'll revisit a lot of the points that come up here in these facts when we go through these examples with you through the presentation. So in terms of the situation overview, the company that we're talking about is Pegasus Corp. It is a light manufacturing business that makes branded home accessories. About 80% of their sales are to the U.S. In terms of financial metrics, it has about $50 million in revenue, $9 million in EBITDA. They design their own products, so they have patents and trademarks. They assemble their products in Canada, but have components contract manufactured offshore. They operate out of a leased facility in the Greater Toronto area. They have 120 employees. And one thing that will come up a little bit later is that the prior tenant in that facility was a heavy manufacturing business that handled hazardous materials. The protagonist in the case, or the client, is Jack Smith. He's 62 years old. He's the CEO and owns 85% of the shares of Pegasus. The reason, or the trigger event that's happening here, is that he's been approached by a competitor with a $53 million offer. The suitor is a company called Unicorn. It's a competitor that trades on the New York Stock Exchange, so US-based company, fairly large, has a $1.2 billion market capitalization. Jack's daughter, Hillary Smith, has been groomed as a successor and is currently operating as the president. And Hillary owns 15% of the company. Jack also wants Hillary to lead the business after he retires, and he's concerned that if Unicorn were to move forward, that they would want to move Pegasus's operations to the U.S. and integrate the business into their Michigan facilities, which could impact Hillary's role. Also, Jack's current lawyer, who we have very imaginatively called company lawyer in square brackets, has been Jack's trusted advisor for over 30 years and has handled all of Pegasus affairs since the beginning, including the writing of Jack's will. So he's a long-standing trusted advisor. As a result of this approach, Jack calls his business valuator for advice and went through a few of the key questions. And some of the questions that he asked were, how much is Pegasus actually worth? Is the offered price reasonable? How real is the proposal? How should he respond? If he shows interest in selling, is there a risk that Unicorn will leak that Pegasus is in sale discussions to its employees, customers, and suppliers? Also, is Unicorn the right buyer? And what will happen to Hillary? And finally, and most importantly, what should he do next? So the CBV suggests to Jack that he can provide advice on the valuation of Pegasus and whether the $53 million proposal is a reasonable one. And he also offered that while he's advised clients on a handful of sale transactions over his career, M&A advisory practice is secondary for him. Given the time-sensitive nature of the approach by Unicorn, one. Secondly, the limited knowledge about potential buyers by the CBV, and third and finally, what other potentials might be willing to pay for Pegasus. CBV suggests that Jack also involved an iBanker that he'd worked with in the past who did a very good job at surfacing value for another client about a year before and really knew the buyer universe well. The iBanker tells Jack that the proposal is not a real offer until the suitor confirms the valuation after completing due diligence. So, of course, any offer is subject to due diligence. And secondly, it's subject to definitive transaction terms. So until those proposed transaction terms are understood, there's really no deal. It may as well be written on a napkin. The CBV determines that the fair market valuation range for Pegasus is $50 to $65 million. And the iBanker determines that the M&A market in Pegasus's industry is robust. There have been several recent acquisitions by both strategic and financial buyers in the 5.5 to 7.5 times EBITDA range. And the iBanker notes that Unicorn hasn't been active, so the suitor in this case hasn't been active in the M&A market, having only completed one acquisition in the last 5 years, and at that didn't pay a very attractive price at 5.2 times EBITDA. When the transaction process and objectives are discussed, the company lawyer mentions that he works out of a small office and has worked on 2 sale transactions in the past 5 years. The company lawyer also has not been involved in a structured sale process before. As part of the discussion of market practice for transaction structures, the iBanker mentions to Jack that the final agreement will have indemnities from Jack in favor of Unicorn that could result in adjustment of the negotiated purchase price, and that a portion of the value that is subject to post-closing adjustments is usually held back in escrow for some period of time post-closing. And finally, should the ultimate buyer retain Hillary, Jack is concerned about an adversarial relationship with Hillary should they have to go through negotiation of post-closing adjustments and release of funds from escrow. Let me see here. I've gotten ahead of myself a little bit. So Jack is insistent that he receive all the proceeds at closing and found the concept of an escrow or holdback offensive. The iBanker points out that the majority of serious buyers would require deal terms that are within market norms, and that off-market requirements may severely limit the competitiveness of a sale process. Suggested that Jack interview 3 M&A lawyers he has worked with before to ensure that he gets best-of-class M&A legal advice. The CBV mentioned that many of these concerns around escrows and holdbacks and indemnities could be effectively addressed through rep and warranty insurance, and the iBanker agreed that was the case, and agreed to reach out to a rep and warranty expert to discuss further. So the questions are here. Jack has some decisions to make now. He's got a few key things that he's got to figure out in terms of responding to this offer, whether he needs to respond to the offer at all. So first question is, should Jack move forward with the company lawyer as his M&A counsel? If M&A counsel is retained, is there a role for the company lawyer? The second question is, how much time does Jack have before he engages M&A counsel? At what point should rep and warranty insurance expert become involved in the process? How will these advisors work with each other and with his existing advisors? And finally, what are the areas where coordination among the advisors are important to ensure a smooth transaction process while managing the costs? So the next couple of slides here, I'm just going to spend a couple of minutes really just setting the table for why it is important to get appropriate legal advice, how that's crucial to the success of the M&A process, and again, focusing on those areas that the financial advisor should be focused on. So this first page regarding the window of vulnerability, why is this session important? This is all about having the company in the market for the shortest period of time possible, so that period of time is the time during which the company starts negotiation with a potential buyer to the time that the transaction closes. Prior to that point, there's really no exposure to the market, so during the preparatory stages, there's not really vulnerability. But once the company's in discussions, there are all kinds of risks that come up. The first is we describe as completion and pricing risk, and that ties to things like market conditions changing during the negotiation, business performance being affected during the negotiation, so there's a negative event that happens to the company. And the longer that window is open, the more likely it is that something like that happens during the negotiations. And also, there may be negative events that happen from the buyer's perspective. The buyer may become subject to a lawsuit, their stock price may fall, they may release a bad earnings quarter and put a moratorium on acquisitions. Again, so those are all risks that really increase the longer the negotiations carry on. And then the other risk that increases the longer the company is in negotiations is disruption to their ongoing operations. And that primarily pertains to leaks that could get back to the stakeholders in the business, but also opportunities for competitors to use the confidential information of the company to their advantage. So in terms of minimizing the window of vulnerability, or in other words, how do you make this process go as quickly as possible? The first and most important thing is really pre-launch preparation to make sure all the due diligence is ready before the negotiations start. Ideally create competitive tension so that you can hold bidders to a timeline and instill some process discipline. Ensure client expectations are in line with market before you start the process. And this is a very important step. If the client has unrealistic value expectations, it's their advisor's job really to tell them whether those are achievable or not and make a call as to whether the company should be exposed to a negotiation. And then, of course, assemble an experienced advisory team. And so that includes, of course, the M&A counsel, an appropriate financial advisor, and if the circumstances warrant, then a rep and warranty insurance expert as well. And then finally, we have a motherhood statement here, which is really just that strong coordination and communication among the client and an experienced advisory team minimizes the window of vulnerability and the risks associated with it. The other point is regarding existing counsel. In this case, given the lack of experience that counsel has with M&A transactions, particularly with structured sale processes and probably also dealing with institutional private equity, the existing counsel lacks market knowledge and would actually have a difficult time keeping up with the timelines in a competitive M&A process, given the lack of bench strength in his firm. That being said, the company lawyer's involvement in the transaction process is essential. So M&A counsel does not replace corporate counsel. They really provide extra depth and bench strength to allow corporate counsel to focus on their role as a liaison and advocate for their client through the process, and also assisting in preparing the company's due diligence. And then in terms of, and then the other point I want to make about the risks regarding engaging inexperienced counsel, some of the specific risks include negotiating off-market deal terms, which would result in loss of credibility and trust with the counterparty. That can affect deal momentum. Also, just responding too slowly can also hurt momentum, and momentum is very, very important in M&A negotiations. And then finally, a lack of judgment on which terms have the greatest impact on realized value, not knowing which hills to die on necessarily, because there's always a little bit of give and take when you get into the specific terms negotiations. So I'm going to just spend about 5 more minutes here going through a few points regarding coordination of advisors and the roles of those advisors in the context of the overall M&A process. So I think you're quickly getting the idea that we're emphasizing the importance of coordination. So the greater the coordination, the faster the process, the lower the deal costs, and the more perspectives you have around a deal issue, the more creativity you can apply in resolving deal issues, and they always come up. And having a multidisciplinary team is essential with coming up with the most elegant solutions. And then, of course, if you have competent help, that minimizes the risk of transaction failure. The first external advisor on the scene is usually the financial advisor or business valuator, and their job primarily is to evaluate the proposal, determine appropriate strategy and response, prepare the client for the transaction process, and then, of course, do the market outreach to the extent that there's a competitive process that is that's undertaken. When you get further into actually proposing terms and negotiating with external parties, you start to bring in the other groups of advisors. But that being said, the earlier you involve those external advisors, the better. In terms of the roles of M&A counsel, I'm just going to have Jake run through a few of the key points around M&A counsel.
Sure. Thanks, Paris. Very briefly, Paris has alluded to the fact that it's important to get your advisory team assembled early in the piece. From the M&A counsel perspective, I just want to make a couple of points. The first is that you can appreciate that many of your clients will be concerned about engaging and incurring a lot of funds and fees early in the negotiation steps. That's fully understood by M&A counsel, and I think the key first takeaway is that just having someone at the table who can give you some insight on the process, the timing, someone who can give you a sense of the cost of the transaction is helpful for everybody involved, because as we all know, a deal without clear understandings on the part of your client is often a deal in jeopardy when they get that first bill from any of the advisors, or when the deal hasn't closed in a month, even though that's an unrealistic amount of time. So that's the first comment I wanted to make. The second comment I wanted to make was a specific one. The first time often that an M&A lawyer can add real value, substantive value, is in the negotiation of the initial paper, whether that's a letter of intent, a term sheet, a memorandum of understanding, or anything else like that. Two ways that I think it's important to have experienced M&A counsel look at that are, A, from a financial perspective, often clients will put in, as you'll be familiar with, financial concepts at that initial stage, and they'll think, we don't need anybody else to look at this, not our valuator, not our accountant, and not our lawyer, but because we understand what the purchase price is. We understand what the business deal is. As everybody knows, that is a dangerous route to go, because in every concept of a deal term, for example, working capital, there are many questions that you're going to want to assess. So, for example, in a definition of working capital, which is one of the examples we're going to go with today, how do you define working capital? Are, for example, the seller's expenses in negotiating the deal included as liabilities in that calculation, or are they excluded? Pretty fundamental point, and everyone will have their own opinion on it. And frankly, it's not a big deal to me as to which way it goes. If I'm on for the seller, I want them excluded. But my point is simply, you want to be clear on that so that when you get down to drafting the paper, there's no misunderstanding as to those key points. The second piece is, of course, legal points, legal substantive points. The level of detail on liability caps, for example. Often clients will say, okay, vendor's liability is capped at X dollars. If you're on for the buyer, you're going to want some exceptions to that cap. How much detail do you get into those exceptions in the letter of intent? And I won't kind of drill down too much more into it beyond saying, thinking about those issues at the outset can frankly save deals. I've seen transactions, and I know you have as well, Paris, that die at the 11th hour because somebody says, we assumed net working capital was X, and instead you'd say it's Y, or we assumed it was going to be a cash-free, debt-free business on closing. Now you're telling us otherwise. So those are my two comments from the M&A counsel perspective.
Perfect. So it's Robin here. I'm just going to jump in quickly on when to get a rep and warranty insurance broker involved in the deal. I'm going to keep it really short and sweet right now because I'm going to get into a bit more detail later on in the presentation on the full process of securing rep and warranty insurance. But for now, I will say that in the worst case scenario, we can get a policy underwritten and bound in upwards of approximately 10 days. And that's if there's a last minute issue that needs to be fixed by use of the product. Best case scenario, the sooner that we get involved in a transaction, the better. It also allows for either the buyer and or the seller to get the maximum benefit out of the rep and warranty insurance product that they're using, which again, I'll go into more detail later in the discussion.
Okay, great. Thanks, Robin. Jake. So just to set some context here for the involvement of the various parties, just wanted to step back for a second. I think many of you have seen this before. This is a Gantt chart for a typical two-stage M&A sale process. The key features here that I want to highlight is that we're assuming that there's about a 6-week preparatory phase, and so that's the time that that the financial advisors are doing their due diligence on the company, preparing the marketing materials, finalizing the potential bidders list, going over potential transaction issues, et cetera, prior to launch. The green items on the Gantt chart really just represent key milestones during the transaction process. So when I describe this window of vulnerability concept, that really starts in this particular case on week 7. So at that point, the outbound calling starts, and there's a period of time of approximately 4 weeks that we would typically allow for the potential bidders to review the marketing materials we provide and then provide the non-binding bids. And then once those non-binding bids are in, we go into the second phase, which is more the due diligence and working toward a binding bid, where we would receive a markup of the definitive agreement from the bidders, so we understand what they have in mind in terms of transaction terms. And then we, at the very end, we're allowing, in this particular case, about 3 weeks to finalize the agreements. And in that particular case, what would typically happen is if we had, say, 6 parties in the VDR and doing management presentations and going through their due diligence, we may decide to work and follow up with 2 or 3 binding bids where we go through a round of negotiations around the specific terms and just see how close we can get to something that's acceptable before we actually pull the trigger. So when we get to this binding bids due milestone for that last 3 weeks, we may actually still have more than one party active in the process that we're negotiating with, just to maintain that competitive tension right to the end. In terms of the roles of the non-financial advisors, I'm going to assume that most of the people who are in this session understand the role of the financial advisor in general terms. The areas where M&A counsel would ideally be getting involved are highlighted in the navy blue, and then the rep and warranty insurance involvement is highlighted in red. So in terms of the key agreements that require involvement, we've got a draft of the NDA, and then negotiation of the NDAs to the extent that there are markups that are a little bit more elaborate and require legal input. Otherwise, more routine things are typically handled by the financial advisor.
And Paris, just on that note, NDA, of course, is a non-disclosure agreement, and as per our fact scenario, the vendor is very concerned about disclosure of this deal. Keep in mind, it's not only the deal terms and the confidential information of the vendor or the target company that are going to be of concern. It's the fact that negotiations are taking place at all. So a good NDA will say confidential information includes the fact that these negotiations are taking place, that there's a sale process in effect, and so on, so that it's not just customers but also employees, suppliers, and so on who are not going to be receiving, ideally, any information that's sensitive.
Yeah. Okay, great. I'm going to speed it up a little bit here. Just a couple of comments on financial advisor best practices. I think it's very important for the financial advisor, as they're cutting the deal and negotiating the deal, to understand how those terms are going to be documented. So, for example, I've seen very elaborate earnout structures where there doesn't seem to be a whole lot of appreciation that is probably 50 pages of drafting to capture that convoluted earnout structure. So a lot of times it is worthwhile to kind of think about more elegant ways to structure the consideration, keeping in mind that you don't want to be getting up to 150, 160-page agreement to document the business agreement. And then the other area where a financial advisor, in conjunction with experienced M&A counsel, can provide a lot of value is really on focusing on what is within the realm of market and what sort of trade-offs are appropriate on deal terms. A lot of times what will happen is lawyers can identify all kinds of theoretical risks in an agreement, and what's required is some people with some business knowledge to actually quantify those various risks and understand the likelihood of those risks coming about. And only when those things are understood can you really make an informed decision about the transaction term trade-offs. And then actually these final points, really all I want to emphasize on this page is that it's important for the financial advisor to actually review the financial schedules, the reps and warranties, etc. The target working capital is always something that is subject to a lot of contention, a lot of negotiation. So it's very important that the financial advisor be heavily involved in the construction or in the structuring of the price adjustment mechanisms, and particularly the target working capital, balance sheet at closing, and other financial schedules that become part of the agreement. So I'm going to turn the floor over to Jake now, and he's going to focus on three things. He's going to focus on the key areas of transaction agreements that concern the financial advisor. So this is not transaction agreement for rookie lawyers. This is really focused more for financial advisors who've had some deal exposure. Second, he's going to focus on current market practice. And third and finally, we together are going to tie those concepts into the specifics of this case. So with that, I'm going to turn it over to Jake.
Great. Thank you, Paris. So we're talking about transaction agreement structure, as Paris has mentioned. And just to reiterate to everybody, by all means, if you have questions throughout the presentation, please send them along. We'll also save some time for questions at the end of the presentation. So the next slide on transaction agreement structure. That's the one we're using. Perfect. Thank you. We're going to talk at a very high level about asset versus share transactions. And when I say high level, of course, we are firmly aware of our time limitations today, as well as the discussion topic, which is really deconstructing transaction agreements. So looking at it from this initial perspective, you've been engaged as a valuator by your client Pegasus Corp, and there is now a discussion around structure of a potential transaction. As Paris has mentioned, it looks like we're going to go to a competitive auction process, meaning that in some ways we control the process. Then what structure makes the most sense for our client? I'm not going to get into tax issues here, of course, for a number of reasons, including the fact that I'm not a tax lawyer. I'm going to focus more on agreement structure questions. So first, let's talk about some of the distinctions between an asset deal and a share deal in terms of the agreement. In an asset deal, keep in mind that the primary actor on the sales side is the company. The company is selling certain or all of its assets, or substantially all of its assets, and the buyer is buying those assets. So you're typically not going to have representations and warranties from the shareholders of the company. So in this case, Jack and Hillary, you may have them guarantee the obligations of the company if the buyer wants to keep them on the hook, but you're not typically going to have the reps and warranties actually come from them. Second point to make under asset purchase agreements is that you can exclude assets and liabilities that you don't want. So that is to say, on the sales side, Jack may say, as we often see on mid-market deals, I have a division of the business which isn't core, but which I'd like to expand after I sell. This is my retirement project. In an asset deal, it's very easy. You just don't include the assets related to that business in the transaction. In a share deal, you'd have to actually transfer those assets out of the business, which could have a tax effect on Jack and or the company. And of course, that's a tax issue we won't get into today, but just to make it clear that in an asset deal, relatively straightforward to take only the assets you want, exclude the assets you don't want, and then do a similar step for the liabilities. Number three, in an asset deal, you're going to need a number of covenants reassumption of liabilities. In other words, in addition to stating the liabilities that are going to be assumed by the buyer, you're going to want to make it very clear how they're being assumed and put as much detail in there so that there's no misunderstanding on the day after closing or 5 years after closing as to whether a given account payable or a given contract or a given piece of litigation actually went over as part of the deal or stayed with the vendor. Likewise, number four, you're going to need assignment agreements. whereby you transfer various assets as part of the deal. And number 5, in an asset deal as opposed to a share deal, bulk sales and retail sales tax legislation are both relevant. Share deal very quickly is going to have, as I mentioned, reps and warranties from the shareholders. For example, here are the shareholdings of each of us. Here's the authorized share capital of the company, and so on. And number 2, which is probably the most important structural piece on a share deal. When you buy a company, you're buying the black box that is that company. All of the liabilities within that black box go over with it to the buyer, which is to say not only known liabilities and ones that are recorded on the financial statements, but unknown ones, contingent ones, inchoate and otherwise. They all stay with that company, and if you're the buyer, you've got to be prepared for that risk. So what we're going to refer to a few times today to give you a real sense of deal metrics in Canada is what we call the ABA 2014 Canadian Private Target M&A Deal Point Study. Everyone will be happy to know that I'll refer to it henceforth as the Deal Point Study. I'm a member, as was mentioned at the outset by Deborah, of the ABA, the American Bar Association, and what the M&A Committee of the Bar Association does is prepare these deal point studies for both the U.S. and Canada. And how they get the data very simply is they look at private company acquisitions by public companies. So they had to be reported in one way or another, thereby allowing the team to assess the data, compile it, and put it in this graphical format for us. So to give you a bit of a sense of the Canadian deal statistics that were utilized in this deal point study, the transaction value range was from $5.6 million to $5.8 billion. They looked at 60 transactions. And as a high-level introductory slide, this is a good one, you'll see that in 58% of the deals, the consideration that went over from the buyer to the seller was all cash. The gray 35% represents some cash, some shares, and or promissory notes and other forms of consideration. That's just an important way to open up the graphical analysis. In terms of the forms of deals, you'll see that 60% of them were share deals as opposed to asset deals or mixed deals. That aligns with my experience. You are seeing more share deals in the recent past. Primary reason, in my opinion, would probably be the tax benefits to a seller, and it's more or less a seller's market still, so that's why they're going to prevail and get share deals where they can. Next, we're going to do a very high-level overview of the primary and material components of a purchase agreement. And again, this could be a share purchase agreement, it could be an asset purchase agreement. The idea is to help you understand when someone references a point of an agreement, such as a covenant or an indemnity, what it means and some of the market practice around them. So we're starting with covenants. Covenants are basically promises contained in a contract by which one party makes a promise to another to perform or not perform a specific action. Examples of covenants include, number 1, really the terms of the business deal. So when you look at a purchase agreement and that first section of the agreement right after the definitions is typically, okay, here's what we're buying, here is what we're excluding, for example, if it's an asset deal, here is the purchase price, here's how the purchase price will be paid, and so on. Those are covenants. Those are just agreements between the parties as to how they are going to structure and close the transaction. The second primary example of covenants in a purchase agreement would be what we call interim covenants. These are covenants that relate to the time period between signing the purchase agreement and closing it. You'll note, and I think we have this slide later, but even if it's not there, you can either sign and close an agreement on the same day, which is to say you sign it in the morning and you close that day, so there's no interim period, or you can sign an agreement today and then close your deal on December 31st. In the latter example, you have an interim period. And the covenants I've presented here give you an example of some items that a prudent buyer would want to see as the deal unfolds. So, for example, you'd want that seller to operate the business in the ordinary course consistent with past practices. If this covenant was not satisfied, you as the buyer would have the right to say, I'm not closing the deal. If you sold assets out of the ordinary course of business, for example, I may no longer be interested in doing this deal.
And Jake, just a quick question for the group. How often do you sign and close deals, or what are you seeing, sign and close versus sign with a close at a later effective date?
The data aligns with what I see, which is that you're seeing, it depends on the size of the deal, but you see a lot of interim closing periods. And the data, at least in the American ABA study, and I'd be happy to flip it to anybody who wants to see that, does show that sign and then interim period and then closing deals are the predominant form. For a smaller transaction, though, signing and closing is often the way to go. If you're the seller, you want to sign that deal up sooner rather than later if you're compelled to sell, because you've got that binding obligation of the buyer subject only to certain conditions to close the deal. Likewise, if you're the buyer and you want to tie that seller up, you want to sign as soon as you can, as opposed to seeking to get consents of customers, landlords, regulatory approvals, and so on. So it really depends on the complexity of the deal and the size of the deal, but overall, I think the data show that it's sign, interim period, and then close. So I think that was a sufficient discussion of covenants in terms of what they are and some samples. From a financial advisor perspective, we've talked about the two components of covenants in a purchase agreement. The client expectations are, of course, key, and I think Paris has done a great job of outlining where Jack really sits in terms of what he wants to see in this documentation. And Paris, this is an auction, so as I mentioned, we really control the process in that we're going to put out a draft purchase and sale agreement with the structure we want, presumably in our case, let's assume a share deal.
Right. So, and I'll jump in here. I mean, generally the covenants reflect the business deal. Most of the aspects of the covenant pertain to consideration, the form of consideration, the price, of course, and how the price is adjusted. So a couple of things that a financial advisor really wants to coordinate tightly with legal counsel on are things like, for example, understanding how the mechanics are going to work around the debt in the company at closing. Are we assuming the debt is going to be assumed by the buyer? Are we assuming that the debt is going to be paid out contemporaneously with the closing of the M&A transaction and the buyer put their own credit facility in place? These sort of details are important when we're drafting the document, and they also pertain to how we document the actual price in terms of the proceeds that are going to be payable to the shareholder after the extinguishment of any outstanding debt and as well as dispersion of any excess cash. Of course, the working capital adjustments, which I mentioned earlier, are very, very important. So there's more than one way to skin that cat. There are lots of different mechanisms for a working capital adjustment, but oftentimes they do involve some target level of working capital. There's a lot of discussion about what is in and what is out in the calculation of net working capital. So all those sort of things require very significant coordination between the financial advisor and M&A counsel. And then the other thing is, when we're talking about expectations, it is important to make the distinction between an asset deal and a share deal for the documentation. Of course, that affects the type of paper that you're going to put in front of buyers. And as Jake mentioned earlier, we're predominantly looking at share deals, and in this fact scenario, it's definitely going to be a share deal since we got significant private equity interest that we'd be canvassing in that case.
Well put, Paris. And I think it's also important to note that this is the section of the agreement that really translates what you as valuators do, what the accountants do, what the financial advisor does into legal language. So to Paris's point, there'll be the expectations of the client. They'll be working with the valuator, for example, to understand how, if you're on the sell side, how your business is justifying the valuation that you're seeking. If you're on the buy side, of course, trying to establish your diligence around that valuation and see if it's high or low. But all of which is to say, this is where the rubber hits the road on all of this. In terms of the consideration going forward, if it's all cash, that's straightforward. We're going to see in the data how often you do get an all-cash deal, but more often than not, there is another component into the consideration, whether it be some shares or some escrow that is in a holdback type situation. So at the end of the day, this is the most business-like section of the purchase agreement. So we've talked about the importance of getting the business terms translated and putting them into the purchase agreement. This slide shows us, in terms of the post-closing purchase price adjustments, on the left-hand side we see that there are no adjustment provisions in 27% of the agreements reviewed as part of the Deal Point study. Of the 73% that include adjustment provisions, we look over on the right-hand side to see what the most common metrics are, and you'll see, just like our example, working capital is the most common adjustment metric. Now, still on the topic of post-closing purchase price adjustments, And this is more for you to understand because as part of the mechanics of a closing and determining, say, working capital, it is of primary importance for the parties to understand both A, how that working capital and how that closing balance sheet will be prepared and the methodology used in preparing it, and B, who actually prepares it. You'll see from the data here that on the left-hand side, more often than not, it is the buyer who prepares the closing balance sheet in order to determine the post-closing purchase price adjustments. And on the right-hand side, you'll see that GAAP, consistent with past practices, is the most common methodology employed to prepare that closing balance sheet. Next, we talked about earnouts. And of course, earnouts are post-closing consideration components that would flow to the vendor, whether that's the shareholder in a share deal or the company in an asset deal. We see here that based on the deal point study, in 75% of the deals, there's no earnout. Of the 25% that do have an earnout, the 53% is other, with earnings and EBITDA showing up as the most common earnout metric in 33% of the deals.
Well, let me just make a point there as well. It's very difficult from a practical perspective to the extent that a strategic acquirer is buying a target company for them to base the earnout on EBITDA, because what generally is going to happen is a strategic acquirer is going to do a lot with the SG&A in the target company. They're probably assuming some synergies, and they generally don't want to pay the target for that. And then you also have just some mechanical challenges around how do you actually consolidate the earnings of the entity post the closing. So those are some of the reasons why you certainly do see quite a bit of earnouts based on earnings and EBITDA. But I think that the real story here is the very large portion of earnouts that are based on some other metric. It could be a drug development company getting phase 3 trials done of their drug. It could be some other very identifiable event, such as you win this large customer or you complete that construction project. So I think that when you talk about earnouts, they really, when you get an earnout in a transaction agreement, the earnout portion can almost be involved as the deal itself. Yep. It's a very, very elaborate process. And so I think that the advisor and the client, frankly, should be very aware of what that does to your timeline and what it does to your deal costs, frankly, when you have elaborate earnout structures.
That's a very good point, Paris. And to his point, earnouts can be some of the most complex drafting for me in a purchase agreement. I really enjoy them because it's where you kind of take the numerical and financial concepts and you have to put them into a really written form that can be understood by everybody, including, God forbid, a judge who may or may not have any experience in finance or business or M&A. So this is a very interesting part of a deal, and as Paris said, it can relate to financial metrics, but it can also relate to milestones of a business nature. Next slide, we're just going to take a few seconds on. This is just really for you to review at your convenience, and as I said, if you'd like me to flip you a copy of the deal point study, happy to do so. This just lets you know the prevalence of some of these provisions in U.S. versus Canadian M&A transactions. Next part of an agreement, conditions. Conditions are, and this comes from Black's Law Dictionary, you won't be surprised to hear, a future and uncertain event upon the happening of which is made to depend the existence of an obligation. I can hear groans around.
Sounds like it's written by a lawyer.
It's written by a lawyer. I can hear groans across Canada right now. So really what it means very simply is this. In an M&A context, you look at the most common example. The buyer's obligation to close a deal is premised on certain conditions being satisfied. Those conditions can be what we call true conditions precedent, which are completely out of the power of the vendor. So an example would be the one Paris gave earlier, regulatory consent. When you're waiting for the Competition Bureau, for example, to bless your deal, that's a true condition precedent. That's a binary determination. The Bureau may say no to your deal, in which case, conditions not satisfied, your deal dies. They may say yes, your deal proceeds as planned, or you can proceed in the absence of such a consent. That's a whole other ballgame. Other conditions would be ones that are within the control of a party. So, for example, you as the seller will not have any material adverse effect between signing and closing. That's one that the seller obviously can control. We'll talk at more length later about some other conditions that are more contentious in the context of a deal like this, but you'll see some examples down below. There have not been any material adverse changes, as I mentioned. There will be no legal proceedings challenging the transaction, and as I mentioned, any regulatory approvals required will have been granted, obtained, or received. So now the financial advisor focus, and really the value added by the financial advisor around conditions would be in speaking to the ones that are more of a business or financial nature, helping the lawyer and the client assess those and push back as applicable. So a good example, Paris, would of course be a financing condition. And obviously in your situation, you're trying to generate an auction, a competitive process. A financing condition, of course, is one of the most dangerous ones from the seller's side, because all the buyer has to be able to show you is, sorry, we weren't able to get financing for this deal, and all of the expenses that you've incurred for valuators, accountants, deal advisors, lawyers, etc., go out the window unless you have a non-refundable deposit, unless you've got some indemnity on that. So financing condition, I'm assuming in this case, Paris, is not likely to be one of the
So the entire point of the competitive process here is to give those bidders 6 weeks in the data room and interviewing management, and conducting their due diligence, reviewing the draft of the SPA, getting to the point where they can submit a bid that has committed financing behind it. So certainly the state of the financing is one of the, aside from the price, it would probably be the secondary focus area when we're assessing potential bids. So any kind of competitive situation, you really wouldn't be looking to have a financing condition in the bids. And so when we're drafting a purchase and sale agreement to put into the data room, in this case, we wouldn't have any language in there for a financing condition, for example.
Okay, great. I'm going to move along from conditions because there's lots of additional data to cover. Next, R&W, standing for representations and warranties. Very simply, representations are statements of fact that induce a party to enter into the contract. Warranties, you'll see, are undertakings that a certain fact is or shall be as it is stated or promised. In practice, as M&A lawyers, we treat them essentially the same. Over time, in the M&A context, the distinction between the two has been blurred. At the end of the day, reps and warranties help your client decrease reliance on costly and time-consuming due diligence because you get promises from the target and the vendors about the status of the target, the status of everything from contracts to environmental law compliance. So what are some of the typical reps and warranties you would see in an agreement? Well, on the vendor side, you would see the first one, for example, that the property and assets of the company, other than leased real property, are owned beneficially by the company, and then some legal language that I won't bore you with, free and clear of all encumbrances. This is the fundamental piece to Paris's point about a debt-free deal. This one rep and warranty is fundamental because what it means is if you buy in an asset deal, you buy, for example, the FF&E of the target company, and you find out afterwards that there's a lien against the FF&E or any part of it by a big bank, this is the representation and warranty you sue the vendor on, and you say, there was an encumbrance, our damages were X, so we're coming after you for X. On the other side of the deal, examples of reps and warranties made by buyers, you'll see the first one is the execution of the agreement does not and will not breach or result in a default under any contracts to which the buyer is a party. So, for example, let's say the buyer is in a lockup situation with another target, and that target has said you won't buy anybody else in the space. Well, if the buyer closes this deal or signs this agreement, they could be in breach of that other contract. As a result of that, that third party could sue your client, in this case, Jack and or Pegasus. This is your protection against such a lawsuit. Reps and warranties are important, as I've mentioned, because they give you a more complete picture of the target. In order to fill out that picture, in an ideal world, if you're on for the buyer, you would get one or both of these representations and warranties. The first one is called the 10b-5 formulation. This is based on an SEC provision in the U.S. that relates to the sale of securities. So it's used and misused a little bit in general M&A parlance because it also is used in asset deals. But suffice it to say that the first one, the 10b-5, says that no rep or warranty made by the target in the agreement or any related documentations contains any untrue statement of material fact or omits to state a material fact necessary to make those statements not misleading. So that is a very broad swath of protection for your client on the buy side. And to add to it, you can sometimes also seek the second formulation, which is full disclosure, which is, okay, in addition to any reps and warranties you've made, which is the first one, you're also telling me that you don't have knowledge of any facts that haven't been disclosed in this agreement that could materially affect the assets or materially adverse affect the assets. All of which is to say these are both excellent to get if you're on for the buyer. You may see them as you're going through agreements. Paris will see them as he's going through agreements. And at the end of the day, we're going to see how often they are used here. You'll see on the left-hand side that in 55% of the examples, the rep is not included at all, and that aligns with my experience. You'll see you get both of them in about 19% of the deals, and you get 10b5 only in about 24% of the deals. The subset shows you on the right-hand side where you get the 10b5 with or without full disclosure, how often it's knowledge qualified, only 25% of the time. And what knowledge qualification simply means is that the vendor is saying, to the best of our knowledge, this is true. And knowledge can mean actual knowledge, or it can include deemed knowledge, which broadens that concept. So from the financial advisor perspective, there are a few things that are important from the reps and warranties. And I think as an overview, before Paris briefly weighs in, this is really on the sell side, which is where we're acting today in our fact scenario. This is where you capture a snapshot of the business. So there will be purely legal reps and warranties. I gave a couple of those at the outset of this section. Then there are more business or financial related ones. So for example, financial statements is a common rep and warranty you would get, and it would be that the financial statements have been prepared in accordance with GAAP. Sometimes it says consistently applied. That is something, of course, the accountants, the financial advisor, the client would have to come together on and agree, because if that can't be given, if they haven't been prepared in accordance with GAAP or IFRS, you can't give that rep.
Right. And what I would say as a financial advisor, what the implications are, you really have to advise your client against trying to do cute things like stop paying their suppliers 60 days before the close, and play games around how they operate the business. They really have to continue to operate the business in the normal course. But the other thing that really does impact the due diligence process is the client's instinct to only disclose that information that's favorable and not to come clean about some of the less favorable items. But if the financial advisor and the client are aware early in the process that eventually there is a reckoning in the transaction agreements and they do have to disclose all material information, positive or negative, you can avoid some pretty tense moments as you get close to the closing where you have to come clean with material information that's been withheld. It can get pretty ugly if that's not managed properly. So from the financial advisor perspective, bear in mind that ultimately the client is likely going to sign a representation saying they've disclosed everything that's material, the good and the bad.
Great. So applying reps and warranties as a concept to our case, I'm simply going to say this. On any deal you're on, whether on the sell side or the buy side, you're looking at the specific attributes of that business when you draft the representations and warranties. In our case, the items I've put down here would be examples of prominent ones, right? These are ones that if you're the buyer, you care about. For example, does Pegasus have all of the IP rights in its industrial designs for these consumer products that it produces? Does it have the IP rights and the trademarks related to those products? So without the IP registered as appropriate, and for example, for a trademark, you'd want a registered trademark because a common law trademark has very limited value, then these reps and warranties become not only important legally, but important from a value proposition basis. Because if you don't have the trademark and Pegasus and or its operating trade name represent a big goodwill component of this deal, then you are, and from a Valuator's perspective, this is fundamental, I would imagine, then you have a challenge, right? If that trademark is not registered, can't be held up, at least in Canada, as a way to stop others from using the brand, then you may not have the protection you thought you had in that brand. Indemnities are another section of purchase agreements that are of extreme importance. To indemnify is simply to restore the victim of a loss in whole or in part, or to make them good or compensate them, really to protect them against a loss that relates to the items set forth in the indemnity. These are important because they allocate risk and responsibility between buyers and sellers. Let me give you some examples. We've talked about reps and warranties, and we've talked about covenants. Well, what if there's a breach of a rep and warranty or a breach of a covenant? How does the buyer get compensated for it? They could sue for breach of contract, and there's nothing wrong with that, but they could also
rely on an indemnity if there's an indemnity in the contract. And more often than not, certainly in the vast majority of deals I've been on, there are indemnification provisions. And what those indemnification provisions do is say, okay, here is a way to get compensation to be made whole in the event that any of these things happen. We've talked about reps and warranties, we've talked about covenants, but you can expand the damages that are covered in terms of indemnification by including other points in there. For example, you could have the buyer indemnified against any litigation expenses incurred in connection with third-party claims. You don't have to go to a court, for example, and argue that, okay, they breached a rep and warranty. As a result of that rep and warranty, I suffered damages of $1 million, but also had to pay legal fees of $100,000. I should be made whole on those legal fees. Your indemnity can be a contractual obligation of the vendor to pay you that $100,000 in addition to the $1 million. The final point, and this is a key one to take away, is that indemnification can protect the buyer for issues identified in due diligence that would not normally represent liabilities of the seller vis-a-vis the buyer. Case in point, we're going to get to later, what if you discover in your diligence of the seller that they're under investigation by some anti-corruption authorities in Canada and the US? How do you protect against that? The answer is you would get an indemnity, because if you don't have much visibility into it, you would want to be very clear that it's not something you are assuming. We'll talk more about that in a bit. Now, most deals include an overall cap on seller's liability. We'll talk about that. We're seeing a trend where the caps have become smaller percentages of the purchase price in Canada, but keep in mind as we go to the next few slides that these caps will have carve-outs, and we'll talk about that. From a financial advisor focus, I think it's safe to say that you're really looking with me, Paris, to ensure that we identify the issues that warrant the standalone indemnity.
Right. Yeah. No, this is, again, going back to that exercise of looking at how plausible a given theoretical risk is and what is the expected value or financial impact of that particular risk, and again, making some judgment calls as to what's required.
Great. So let's jump to our example then. This is a real-time case study. So the piece here is we're on for the vendor, of course, and during due diligence, Unicorn, the buyer, the potential buyer, has discovered that Pegasus is currently the subject of an anti-corruption investigation involving authorities in both Canada and the U.S. So this would be the Corruption of Foreign Public Officials Act in Canada or the Foreign Corrupt Practices Act in the U.S. A couple of things for you to take away, and again, this is just an example, but it really gives you a flavor for the nuances and complexities of something like this. First thing is that the target, in this case Pegasus, is likely to resist sharing their confidential information to the extent that it relates to this investigation. In other words, they're going to say, no, we're not going to show you this. You haven't bought us yet. We'll disclose a little bit to you about our strategy, a little bit to you about our defense, but we're not going to let you completely into the tent on this, meaning, as the buyer, you're flying a little bit blind on this. You're going to need whatever protections you can to ensure that this liability is not yours if that's the business deal. Another thing to keep in mind as you acquire this liability, and I've unfortunately seen this in the context of litigation, if you buy the company, let's say it's a share deal, and therefore the liability, if any, that arises from this investigation flows with the company, keep in mind that it's likely the executives are going to move along to other companies at some point in time, and they're not going to necessarily help you. If they're not shareholders, they're not party to the share purchase agreement. You may not get the cooperation you need to challenge this anti-corruption investigation. So again, now you're flying without perfect information, and you may not have the access to people you need to defend this. A third piece, which is purely a business point, but again, one to just raise, what if the target relies on corrupt practices as part of its business model? We've seen in the press lately, there are some companies, some based in Canada, some based around the world, that at least in some areas of the world have found it necessary to engage in practices that would be considered corrupt under this legislation. That is an absolutely fundamental business point you have to assess with your client. Are you still going to do the deal? Because if you're, in our example, Unicorn, public company, you're going to have, I would imagine, very strict compliance regimes in place and so on, you may say, we can't do this deal. You carve out the corruption aspect of this business, it's not worth it. The valuation doesn't justify it. So finally, from the valuator's perspective, probably the most important part, how do you place a number value on the potential damages here? There are no limits to the damages that could be suffered. The Walmart investigation, I understand from one of my colleagues, the total costs are approaching $1 billion. That includes the cost of the investigation, sanctions, not to mention reputational risk. So it's tough to give an unqualified value, making your job very tough if you're on for the buyer or the seller here, and you're asked to put a value on the potential liability of this anti-corruption investigation. So we've talked about liability, and now, again, given that we're on for the seller, one of the key things we want to talk about with them is how do we cap your liability, or at least manage your liability. Most deals have a deductible or tipping basket to limit the seller's liability. We'll talk about those in a moment. Baskets are a threshold that aggregate losses must hit before the seller is liable to the buyer, while caps provide a ceiling on the seller's liability to the buyer. I'm going to illustrate this with a couple of simple examples. So in the first example of a basket, we have a deductible, which is present in 36% of the transactions in our deal point study. You'll see there that in the deductible, the sellers aren't required to indemnify the buyer for losses until the aggregate amount exceeds $300,000, in which event sellers are only responsible for the dollars above that deductible. Next example is first dollar or tipping basket, which is more prevalent. Sellers are not required to indemnify buyer for losses until the aggregate amount of losses exceeds $500,000, in which event sellers are responsible for the aggregate amount of all losses. That could also say from the first dollar. And then the third example is a combination of the two. And the idea is very simply this. If you're on for, in our example, Jack or Pegasus, you want to be very clear about the limitations of liability that are on the table. And as Paris has noted, since we're kind of driving this sale process, we want to be very clear in our draft purchase agreement which of these combinations we want to put in. You'll see very briefly here some data around the baskets. Deductible is the second most prevalent, with first dollar or aggregate losses being the most prevalent, that being the blue one. Caps, very important data here. You'll see that the cap in 60% of the deals was less than the purchase price, and then in 19% of the deals was equal to the purchase price. And now cap amounts are the percentage of transaction value. Again, this is one you can certainly take away, but you'll see some good data there on where those caps come in. Now keep in mind something very important. The caps on the seller's liability always have exceptions. And we're going to talk about those exceptions in the next slide. So if you're on for the buyer, you can imagine, as you look at these standard carve-outs, or at least more typical carve-outs, if you look down at fraud, which is fourth from the bottom, 1, 2, 3, 4 from the bottom, you'll see that in 77% of the deal documents studied, there is a fraud carve-out. That simply means that in the event of fraud, there's no cap on the seller's liability. That would probably sound reasonable to all of you. Where it gets more interesting is where, if you're on for the buyer, you look at the more important reps and warranties and other areas of the agreement, and you say, okay, in our deal, for example, that IP piece, if they don't have that trademark, to come back to that example, then again, this valuation is completely undermined. So there's no way we're going to cap your liability at the purchase price or even a component of the purchase price vendor, because without unlimited liability on IP, we're not doing this deal. Thus will begin a long negotiation where you go back and forth and both parties decide whether the deal's worth doing with some compromise on that. But at the end of the day, this is a liability allocation piece. Final piece for me, escrows and holdbacks, and I'm not going to spend a lot of time on this, but in high-level terms, we're talking now about ways that the buyer protects itself by holding on to some money, either directly or by putting it with a third party. This, of course, is not going to be good news for our client Jack, because he's going to want all cash, he's going to want it all on closing, and Paris is going to slam the table until he gets it. But if I'm on for the buyer, I'm saying, hold on a minute here. We're going to put some money in escrow for one or both of the following purposes. The first is an escrow to backstop the closing date purchase price adjustments. So for example, if you, Jack, or you, Pegasus, owe us money on working capital adjustment, I want some money in escrow, that is to say money with a third party that I can claw back against to get that money. So I don't have to come after you. I don't have to sue you. I don't have to prove to a court that you owe me that money. The second type of financial escrow you'll often see is an indemnity escrow, and it segues perfectly from the previous slide. That's where this money is put aside for a separate reason. If I come after Pegasus or Jack for a breach of reps, warranties, and otherwise under the indemnities, I can claw back against the indemnity escrow. These are a growing trend. Again, they just make it easier, and I put that in kind of italics if not quotations, because at the end of the day, this money is going to sit with a third party who's going to be probably more risk averse than anybody else in the piece, and if there's any dispute over that money being released, they're going to pay it into court in any event. But there is some advantage to not having it with the vendor, because the vendor, of course, could leave the country, could spend it, and so on. So escrows in that sense make sense. At a minimum, a holdback, which is where the buyer holds the money back, is a nice idea for the buyer, less attractive to Jack in our case, and Paris is is nodding his head in fervent agreement, because of course the risk there is the same risks we had on the sell side reversed. Buyer could leave the jurisdiction. Buyer could claim that there's no amounts owing to the vendor and could just claw back against those holdback amounts. Document escrow, very briefly, is just the concept that you have documents, once they're finalized, you put them in an escrow concept so that nobody can come back the 5 minutes before closing and say, oh, we have one more change to the purchase agreement, and thereby creating a ton of issues and questions and challenging the deal. It's a way just to ensure certainty on agreement of documents. So in terms of escrow, some very simple data here. You'll see no separate escrow in 77% of the deals studied. Of that 77%, in 56%, there was no indemnity or escrow holdback, and you'll also see that there was a true-up payment. This is now for a purchase price adjustment. In 24% of the deals, you could dip into the indemnity escrow to true up your purchase price adjustment post-closing step. And then very briefly here, escrows and holdbacks as a percentage of transaction value. You'll see it's really all over the map. And again, you can look at this at your own.
But the majority of them are under 10%.
Yeah.
10% or less, generally market.
And the rule of thumb that a lot of M&A lawyers like myself have with the deal point study is that if it supports your point, as this one appears to do for Paris and our client, then you cite the deal point study. If it doesn't support your point, you point to the X% that are indeterminate or do not fit the data that you are rejecting. Statistical summary there, again, just tells you a bit about the allocation of minimum and maximum escrows and holdbacks as a percentage of deal value, along with mean and median. Financial advisor focus, we've talked about this as we've gone through it, but really, Paris, I understand that the best thing to do would be to sit down with your client. I explain it on the legal side. You walk them through it and say, okay, given the specific facts and context of this deal, here's what I think is a reasonable one given the market.
Yeah, this is really a value at risk analysis. Again, I've talked about this throughout the piece. The point here is you probably look at 10% as a starting point, and then you talk about the factors that suggest there's more or less value at risk here in this situation than average. In this particular case, we've got a company that is a manufacturer that's been around for quite a while. It's a significant exporter. This is not the sort of business that has a whole lot of risk. It's not a technology business. It doesn't have a lot of, it has maybe a little bit of fashion risk, but not a whole lot of obsolescence risk per se. So, as the advisor, I would be making an argument that we should be starting at a lower level, and so we might write into the document that we're looking for a 5% escrow, for example, and let people mark that up and see what, if they want a higher amount, we can turn that into a negotiation.
Right, and a number of things are going to play into that negotiation. If we had more time today, we would enter into a mock negotiation, but Paris said it well. My final comment here and on my section in general is that you always want to be cognizant as the valuator, as the financial advisor, and certainly as the client about cost creep. So it's one thing to agree to an escrow, but you want to be very careful about understanding who's paying the fees of the escrow agent. And they're not huge, but you know what? $3,000 to $5,000 to set it up, and probably $1,000 or $2,000 a year to process it. They start to add up when you build it into all the other fees that are going to be undertaken by your client. And also, don't forget the cost of having your lawyer negotiate that escrow agreement and the related mechanics. On some deals, I've pushed back, and the buyer has picked up that cost because it's a buyer protection piece ultimately. So why shouldn't the buyer pay for the benefits of getting it? That is all from me, and I'll be back later in the piece.
Yeah. So in terms of a situation update, so what Jake and I have really walked through up to now is the work that's been done to get to the point where we've got a draft transaction agreement to put into the data room or the VDR for bidders to mark up and submit with their binding proposals at week 17 or so in the timeline that I provided earlier. So just regarding a situation update for Robin to be able to run through some of her numerical examples, we're going to fast forward through the process, and of course, because we get to make up the facts as we like, we got a very happy ending here. So in terms of the situation update, we've run our auction, received 15 non-binding bids. Of those 15, the 6 best proposals got into a second round. So those second round participants got access management presentations, got to do some management Q&A, did some site tours, got a chance to spend 6 weeks going through a VDR, and of course marked up our draft transaction agreement. Of those 6 folks that made it into the second round, most of them were private equity funds. One operating company that sold different products but through similar channels also made it into the second round. Unicorn submitted a $55 million bid. They were actually a little bit flat. They did come up a little bit from their initial offer, but just didn't really fit in with the best 6, so didn't make it into the second round in this particular case. So again, this is engineered to illustrate the point that a lot of times if you go to a process and you do the market outreach, you're not the party that approaches you isn't necessarily the best buyer for your company, and it's important for a skilled financial advisor to do their job and make sure that they're surfacing the outlier in the field of potential buyers. In terms of the binding bids that were received, 2 parties didn't get to the point where they got to a binding bid. Of the 4, the highest offer was a $63 million offer by the strategic acquirer, but the markup of the SPA was very heavy, and the Pegasus facilities would be closed post-closing. So there were career implications for Hillary. It looked like it was going to take a pretty heavy lift to get to a close on the deal terms, and in Jack's case, for the sake of $3 million, he really wanted the peace of mind of knowing that his company was going to be continue to run in the current operation of Hillary, and he wanted to see Hillary lead it. So Corner Rock was the leading private equity bidder in this case, with a $60 million proposal. The markup of the SPA was light because as a sophisticated buyer, their expectations were in line with market, and in this particular case, the investment banker and the and M&A counsel tabled an SPA in the data room that was in line with market. And then there were 2 other lower private equity bids. So Corner Rock Equity Partners wins the proposal. So the agreement is not yet signed, however. We have a favorable markup, and we're still continuing to move along in this case with trying to finalize the Corner Rock equity deals, except we have some of these escrow issues. Recall, Jack is dead set against having any kind of a material escrow or holdback. Bear in mind as well that he is now going to be sitting opposite Hillary post-closing in a negotiation if they're talking about post-closing price adjustments and releasing funds from escrow. So to address some of those issues and the types of solutions that rep and warranty insurance can provide, I'm going to turn the floor over to Robin.
Perfect. Thank you, Paris. So I'm not sure what everyone's familiarity with the product is, so I'm going to do my best to give a good general outline of what it is and what it does, and also give some situation-specific examples, relaying it back to our Pegasus example. So rep and warranty insurance, what is it? Basically, it's an insurance product that we wrap around all of the reps and warranties in an underlying sale purchase agreement. The purpose of the insurance product is obviously to protect either the buyer or the seller from any financial loss as a result of a breach of a rep or warranty. So market overview. Rep and warranty insurance is by no means a new product. I believe it was introduced to the market in around 1998. So it's almost 20 years old. However, it's become much more widely used in the States over the last 5 years, and Canada, I would say we've seen a huge jump in the use of the product in the last 2 to 3 years. I've got some stats in there on the utilization of the product internationally. I won't go through them, but I will point out Australia and Sweden. I'll point to the amount of deals that use rep and warranty insurance. Over there, they use it almost like title insurance. So it's becoming more popular in the States, and Canada is slowly catching on as well. One of the reasons why it's becoming more popular, I believe, is premiums are going down. So this includes both premiums for the risk, so a rate charged per limit, and also a major factor, I believe, for Canadian deals is minimum premiums have gone down quite a bit as well. So what does that mean? It means on a risk that any risk under $100 million, where in the past 5 or 10 years ago, the minimum premiums on a deal would be $250,000. So on any deal that was, say, $30 to $50 million in enterprise value, the pricing would not make sense. Now, more recently, I've seen premiums as low as $75,000. So what that means is it makes more sense on the smaller deals, and it's an option that a lot of buyers and sellers are considering. There's also a lot more markets that are involved in the rep and warranty space. So again, in the past, where there used to be 3 or 4 insurers that wrote it well, nowadays we've got 6 or 7 markets throughout Canada and the States, and then even more markets than that if you look into the UK. Another reason for increased popularity, I would say, is comfort with the product. So we've seen a lot on the private equity side where if we've got a Canadian private equity firm that's looking at a U.S. target, more often than not now, U.S. targets are saying, listen, we don't want you to even come to us with a bid in an auction process unless you've got rep and warranty insurance attached as part of your bid. So again, it's forcing Canadians to use the product, become more familiar with it, and using it more as a tool. Okay, so policy types. There are 2 types of rep and warranty policies. You've got buy-side and sell-side policies. The difference being mainly it's who is the insured under the policy and who will be making the claim to the insurance company in the event of a breach. So as it describes the buy-side, you've got the buyer, that's the insured. In the event of a breach of a rep or warranty, the buyer, instead of going to the seller, bringing suit or making a claim, the buyer's not going to make a claim directly to the insurance company. The insurance company then, in effect, is stepping into the shoes of the seller post-transaction and would be paying out directly to the buyer in the event of a breach. The only time that the insurance company, and we'll talk about this a little bit later when we talk about subrogation, but ideally the only time that the insurance company will go back against the seller and subrogate for their loss is in the event of proven seller fraud. So it's a very efficient product on the buyer side. Me as an advisor, I always push my clients, even when they're selling a company, to try as much as possible to have the buyer buy a buy-side policy. Again, we'll talk about the structure, but just because it's a buy-side policy does not mean the buyer necessarily needs to pay the premium. So a lot of the times we'll see the sellers pushing for a buyer to buy a buy-side policy, and in exchange will actually pay the premium on behalf of the buyer. However, that said, there are times when a buy-side policy is not feasible. So sometimes you've got a buyer who's not comfortable using a rep and warranty insurance product, and will only get the deal done in the event that there's the original indemnities given by the seller. In that instance, our kind of backup plan here would be a sell-side policy. So what happens here is, in the event of a breach, the buyer would make a claim against the seller. The seller is giving the same indemnities that they would give without the rep and warranty insurance. But in this instance, the seller can then go back and make a claim against the insurance company and have the insurance company either pay that loss on behalf of the seller or indemnify the seller for any loss that they've paid to the buyer. Again, the structure depends on the objectives of both the parties in the deal. So bringing it back and applying this to our situation application, we've got the seller, which is Pegasus Corp, and the buyer, which is Corner Rock Equity Partners. This diagram illustrates in the most simplistic fashion possible the buyer and seller risk in any given transaction. So the combined total risk would be the enterprise value under the sale purchase agreement, which in this instance, for the Pegasus example, we've got a $60 million enterprise value. The place on the bar chart where the risk shifts from the seller to the buyer would be whatever the negotiated indemnity cap is on the deal. So again, for this Pegasus example, we're saying that the buyer is demanding a 20% indemnity from the seller. So they're looking for a $12 million indemnity. Jack, however, as we discussed earlier, is not keen on giving such a high indemnity and or escrow and is looking to use rep and warranty insurance as a tool to bridge this gap. So I've put in a dotted line underneath there. That's just representing Jack's ideal indemnity. If possible, he'd like to lower this down to anywhere under $1 million. Okay, so as discussed, our first suggestion would be if Jack could request that Corner Rock use buy-side rep and warranty insurance in order to bridge this indemnity gap. So again, going back, Corner Rock requires a 20% indemnity in order to get this deal done, which equates to $12 million. This requested indemnity from the buyer would become your rep and warranty insurance limit. Jack's indemnity on the deal, which you can see here, his seller risk, is significantly reduced as a result of the use of the rep or warranty insurance. So the insurance would pay for losses as a result of a breach direct to Corner Rock, and as soon as the policy deductible has been eroded. So on any rep and warranty insurance policy, there is always going to be a minimum deductible. Most insurers these days are offering between 1 to 2% of the enterprise value as a minimum deductible. So for this example, we'll say we get it down to 1%, and that represents a deductible that could be as low as $600,000. Again, you can get creative with the use of the rep and warranty insurance, wherein the deductible could be borne 100% by the seller, so it could be all Jack that has to suffer a $600,000 loss, either by way of indemnity or through an escrow, or it could be 50-50 between the buyer and the seller through a buyer deductible and seller escrow, or it could be all buyer borne. So again, these are things that you can play around with depending on your deal and the negotiation process. So what do we get as a result of using the buy-side rep and warranty insurance? The buyer gets their requested $12 million indemnity on the deal, and Jack wins as well in getting his significantly reduced indemnity or escrow obligation. So he's now down to, at a maximum, $600,000, whereas before they were asking for $12 million. Another factor, which we will discuss in a couple of slides, but premium payments. So I will mention right now, again, a crafty part about rep and warranty insurance is you can get creative on who pays the premium. So as I discussed before, just because it's a buyer side policy does not mean that Corner Rock necessarily is paying entire premium. In this instance, because Jack is now has much lower seller indemnity, Jack may offer to pay a portion of the premium, or Corner Rock could give a lower bid. There's many different factors that you can use to negotiate. Moving on, if for whatever reason Corner Rock was unwilling to purchase the rep and warranty insurance or get a buy-side deal instead of having Jack put up that $12 million indemnity, and they were insistent that Jack needs to put it up, we could go on to a sell-side policy. So what would happen here is, again, the sale purchase agreement is crafted in the same way as though rep and warranty insurance is not used. Jack, as a seller, would still be on the hook for the full $12 million indemnity. However, then he could look to secure rep and warranty insurance on that particular indemnity. So the limit in this instance becomes whatever your indemnity cap is. So again, it'd be the $12 million or 20%. And in the event that Jack is required to pay out to Corner Rock in the event of a breach, Jack can then turn around and claim against the insurer to pay on his behalf or to reimburse him for any loss that he's paid. Again, on a sell-side policy, there is still a minimum deductible. So this is still 1% of the enterprise value. It doesn't matter if it's buy or sell side. And again, you can do the same thing as we did on the buy side, where it could be a combination of buyer and seller deductible and escrow, 100% seller escrow, or 100% buyer deductible. All right. In terms of pricing, so the way that we price these out, or the pricing trends that we've been seeing, is it's called the rate on line. So the rate on line that we're generally seeing is 2 to 4% of the limit of liability. The limit of liability that we're talking about in this instance is for the buy side, whatever the desired indemnity amount is on that particular transaction. So in the Pegasus example, we use 20%, so $12 million. That becomes your insurance limit. And your premium on that is anywhere from 2 to 4% of that $12 million. So for this particular example, we're looking at $240,000 to $480,000. Again, if we were using a sell side example, the limit becomes whatever the indemnity cap is on the deal. And again, we use the same amount, 20%, and giving us the same premiums. The minimum retentions we spoke about briefly, but it's anywhere from 1 to 2% of the enterprise value. Again, it can be borne by the buyer, the seller, a combination of both. Some of the more advanced things we've done on the policies is we can offer drop-down retention provisions. So depending on the structure of the deal, if you were willing to accept a higher retention for the first year after the deal closes, you would see a lower premium, obviously, because the insurers have a higher attachment point. And then some of the insurers will say, okay, after 12 months, we'll have a 5% of enterprise value deductible on our policy, and then after 12 months, we agree to drop down to, say, 1 or 2% of the enterprise value. Another cost associated with the rep and warranty insurance is the due diligence fee. So this is a one-time fee that's payable after the time that you've got a non-binding indication, which I'll talk about the process in a minute, but it's payable directly to the insurance company, and what this does is it covers their costs. When they go into the due diligence phase on a deal, they're going to be engaging third-party counsel to go through and piggyback on the diligence that's already been done by the advisors. And this is going to cost them out of pocket, so this is their protection. In the event that the deal falls apart on the buyer-seller side for whatever reason, it keeps the insurance companies from being out of pocket on these expenses. So submission considerations. Most importantly, when you're looking at how to structure a rep and warranty policy and what you're going to ask for from the insurance companies, you need to think about what type of duration do you need on your reps and warranties? What type of survival are you looking for? What type of limit is required? So what do you want as your indemnity cap? Or what is your indemnity cap if you're a seller? Or what do you want as a requested indemnity if you're a buyer? And what sort of deductible could you support on a deal? So duration of the policy, I've done a deal before where there was a seller who was willing to give indemnities on a particular rep, but they were only willing to give them for 18 months post-close. The buyer was looking to get this extended out to 3 years, and we used rep and warranty insurance as a good way to bridge that gap in the survival period. Coverage limits, as we discussed on the Pegasus example, rep and warranty insurance is obviously a great tool in the event that there's some sort of a gap between what the seller is willing to give as an indemnity and what the buyer is requesting on the deal. Again, buy side I think is a little more crafty than the seller side. The seller side, your limit is going to become whatever your indemnity cap is on the deal. There's no getting creative here. The buy side is a little bit different in that you can choose a requested indemnity. So we've seen deals where the seller's willing to give, say, 1% indemnity or an escrow, and the buyer's wanting to get up to 50, even 100% of the purchase price insured through an indemnity or through the rep and warranty insurance. And in that case, we can secure that as well. Deductibles, again, minimum retention is 1% of the enterprise value, but it doesn't mean you have to go that low. A lot of the times, if there's already a seller that's willing to give, say, a 5% escrow on a deal, the insurers will do their best to match up their deductible with whatever escrow is already written into the sale purchase agreement. Obviously, the higher the deductible that you're willing to support, you'll see a lower premium given by the insurers. What is not covered, which is most important, I believe. Any sort of known breach in advance of closing, so known by the actual deal team, is not going to be covered by rep and warranty insurance. As Jake mentioned before, a lot of the items that are flagged throughout the due diligence process, so if there's ongoing litigation, any issues, I've seen issues before with net operating loss calculations, prior usage, issues like that are often not covered by rep and warranty insurance. Again, it's the premise that insurance is not meant to cover or to insure a burning building. So if there's something already there, we already know it's there, it's been flagged, you've still decided to move forward with the deal, you cannot cede that risk over to insurance. So you've got two options at that point. If there's something that comes up, you either get comfortable with the exposure and you decide to move forward, or you request a separate indemnity from the seller.
And Robin, that's also a point of contention often in the purchase agreement itself. The seller may argue that the buyer should be prejudiced by any knowledge it had pre-closing. So if you knew of a breach, you didn't tell us about the breach, you closed on that breach, you can't come back to us after the fact, versus if you're the buyer, you say, why should I be prejudiced in any way by my diligence? I may have strategic reasons for closing and coming after you afterwards. So it plays into that piece as well,
Yeah,
that knowledge of the
absolutely.
buyer.
Absolutely.
Okay.
Other things that are not covered by reps and warranties, any breach of a covenant, pension plan underfunding, purchase price adjustments, breach of any forward-looking statements, and fraud or misrepresentation by the insured. And the insured here, obviously, it depends on which side of the policy you're buying. So on the buy side, any fraud or misrepresentation by any of the buyer side deal team members, and on the seller side, obviously, fraud or misrepresentation by the seller. Just to move quickly through other considerations, here's again where you can get a little bit more crafty with the rep and warranty insurance, and it's better to know earlier on in the negotiation process versus later, but the definition of loss in your underlying sale purchase agreement may affect your rep and warranty insurance. If you've got any sort of a agreement that allows for indirect, consequential, or multiplied damages coverage, you'll want to let the rep and warranty, you'll want to negotiate this sooner rather than later with your rep and warranty insurance provider. Oftentimes, there is an exclusion in their base wording. However, they will remove it and allow for indirect, consequential, and multiplied damages payouts. They will often charge extra premium for that. So generally, it comes in around between 10 to 15% in additional premium. Subrogation, as I mentioned before, on a buy-side deal, you want to make sure that your subrogation provisions on your insurance policy are limited so that the only time they can go back against the seller and try and claw back for their losses is in the event of proven seller fraud. Anything more than that, then you're really getting away from the point of the rep and warranty insurance, which is, on one side, to be beneficial to the seller that they don't have a lot of obligations after close under the agreement. Retention drop-down we discussed earlier, so I won't go over that again. And then a materiality scrape, if there's one in your underlying sale purchase agreement, just quickly you want to make sure that you point that out and you get the rep and warranty insurance policy to cover that as well, or to follow suit. Items that are seen by insurers to be higher risk, but they will cover them, and we're seeing them quite commonly now, is environmental, cyber issues, product recall, or warranties. Just because they're higher risk does not mean that they won't cover them. They will be flagged, and the insurance company in the diligence process will likely want to go through and make sure that there is enough insurance on the target company's program, so underlying insurance program, to cover off the exposure that they see. So if there's a huge environmental exposure, the rep and warranty insurance provider is going to look through and make sure that there's a specific and standalone environmental liability policy with adequate limits to cover any loss so that they're not attaching for $1. And just to touch briefly on the timeline, what we do first when we get a submission handed in and it works well with this example is that we put NDAs in place. So whether that means having the insurer sign a joinder, attaching them to an NDA that's already in place, we as the broker would sign a similar joinder, or we can sign separate and standalone NDAs. Then we would receive your any draft transaction documents, so draft sale purchase agreement, and a CIM or financials for the underlying. With that information, we can send that over to the insurance companies. Us as brokers would send it out to 4 or 5 insurance companies, again, depending on the metrics of the deal and which insurers we know would be interested in that particular risk. We would send out what terms we want, and we would be able to get a non-binding indication letter back in anywhere from 24 to 48 hours. Again, as the broker, we would put together a proposal for the client's review, just showing the different terms and conditions, any sort of feedback that we got from the insurers, i.e., we're going to pay special attention to the environmental risk, or we're having trouble getting our heads around the cyber, so just a heads up that this may be cause of concern once we get into the diligence process. They can also go through and look at the draft sale purchase agreement, and if there's any reps that would cause trouble that the insurers know about that would be troublesome in the diligence process, they'll give you a heads up at that time. Benefit of this whole process is up until this point, until we as the broker come back to you with 4 or 5 different options outlining the pricing, the terms, the conditions, there is no upfront cost to this insurance product at all. So again, I stress there's no downside if at all you're struggling, or even not even struggling with the transaction yet, but you just want an extra tool in the negotiation process. It's worth it. At that point that you have it in your back pocket, whether or not you use it or you decide to move forward with an insurer or an underwriter, you could walk away at that point and not pay anything. So there's really no risk. If at the time you do decide to move forward with the insurance, you would select which insurer you believe is best for your deal. You would pay that due diligence fee, which market standard right now is anywhere from $20,000 to $40,000. And that, again, is non-refundable. It goes direct to the insurance company. It covers their third-party counsel cost. The insurer and their third-party counsel would then begin their due diligence process, and depending on the timeline of the deal, they can get it done anywhere between 5 to 7 business days. We've wrote 2 to 10, but they can stretch it or do it quicker depending on the timing. At the end of that due diligence process, the last thing that they'll do is they'll have a bring down due diligence call. They'll have it with whoever the insured is under the policy, their advisors on the deal, so including tax, legal, and their third-party counsel as well. So they'll just go through any flagged items they found in their due diligence process, and some general questions on the transaction. Then the policy is basically ready to bind, and they'll bind it up simultaneous with signing and or closing. The buyer of the policy would then deliver a no-claims declaration that just says, we're not aware of any breaches of the current rep or warranty as written in the sale purchase agreement. They sign off to that, and the premium is paid. The premium that we discussed is a one-time premium. It's payable at the onset, and it lasts for the entire duration of the policy period. Typical survival period on a rep and warranty insurance policy is 3 years for general reps and 6 years for fundamental and tax reps. And then just last, and I'll go through this quickly so we have time for questions, but just going through briefly some of the examples of when, we've seen buyers in a transaction request that rep and warranty insurance coverage is used. Again, we talked about this briefly on the Pegasus example, but enhancing the amount or the duration of the indemnity, so the survival period of your reps and warranties, or if you were looking for a 50% indemnity as the buyer and the seller was only willing to give 5. This is a great way to bridge that gap. Distinguishing your bid in an auction, we're seeing this quite often now with private equity firms where you almost can't walk into an auction on a U.S. target without having rep and warranty insurance attached as part of your bid. Ameliorate collection concerns. Again, I worked on a deal once where there was a buyer. They were looking at buying rep and warranty insurance because the sellers on the other side, there was, I think, 80-plus selling shareholders. So for the buyer, that would have been a nightmare in the event of a breach of a rep or warranty to try and track down all selling shareholders. So the rep and warranty insurance was a better option. Protecting key relationships. So pulling this back to our Pegasus example. In this example, we've got Hillary that's a partial shareholder. So she's got a portion of her, I think she was 15% of it?
15%.
Yeah, 15% of the shares of the company. So if she was rolling her shares, she was management pre-sale, she's going to be management moving forward. If I was the buyer, I would not want to be buying that company. In the event of a breach of a rep or warranty, now I have to bring suit against both Jack and Hillary, who's now involved in managing the company that I've just bought a majority stake in. So again, it can provide a great buffer. So, as we discussed, the seller's only going to go back against, or the insurance company will only go back against Hillary and Jack in the event of proven fraud. Other than that, they'll never know. Protecting the deal, again, as Paris and Jake spoke about earlier, avoid drawn-out negotiations. So any time that you can have an additional tool in your pocket to just make the negotiations go quicker, prevent the deal from dying. We see some clients who will look and they'll get non-binding indications on rep and warranty insurance. They've never gone ahead with the actual insurance product and they've never bound it, but it's proven to be a great tool. So in the event they get stuck on some piece of the negotiation on the sale purchase agreement, at least then you have a dollar value attached to what it's worth. So you can say to whoever that other party is, listen, you can either go ahead, we have an insurance product that will protect you from whatever we're standing off on, or you know what, we just find another way to get around it. So, and then flipping over some of the instances why sellers would request rep and warranty insurance usage in a transaction. Again, distributing sale proceeds. So oftentimes, again, on the PE side, I dealt with a transaction one time where there was a seller. The target company was their final investment that was left in a particular fund. So they were looking, once they sold this investment, they were looking to close up their fund. We actually managed to structure a transaction such that the seller had no indemnities, no escrow, no obligations post-sale. So for the seller, that was great. They were basically able to just walk away from the transaction as that closed. Increase the purchase price. What we're getting at here is you may be able to offer a greater indemnity in an auction process or in a sale process as the seller than you would otherwise be willing to give, knowing that you could potentially insure that indemnity through seller's reps and warranties. Supplement disclosure process, again, it's just another set of eyes, well, two sets of eyes, really. You've got an insurer now that's looking through all of your diligence, and you've got their third-party counsel that's doing another review. Protecting passive sellers, one of the best examples I can give of this is I worked on a deal where it was a family business that was being sold. There was 2 family members that were actively involved in the operation of the business, and the rest were really passive sellers. In that instance, all of the other passive shareholders decided to get together, pay the insurance premium, get a sell-side policy, and at least then have the peace of mind that they're not on the hook for any indemnity post-sale. Reduce contingent liabilities, again, it kind of goes hand in hand with that distribute sale proceeds, but just, avoiding having to have any capital tied up in escrow on environmental reps and warranties or cyber reps and warranties or whatever the case may be. I think that's it for...
Okay, great. Thanks, Robin. So I'm just going to come back around to the punchline, I suppose, in terms of the proceeds, the pre-tax proceeds that would be made available when we bake in not only the transaction adjustments, but also the transaction costs. So in this particular example, again, we negotiated a purchase price of $60 million, and let's just assume that the target net working capital in the agreement was $6.5 million, and after the post-closing balance sheet was trued up, we actually had $6.8 million in net working capital, so there was a positive adjustment in favor of the vendor here for an enterprise value of $60,300,000. And then, of course, when we make adjustments for the distribution of the excess cash and then as well retiring the debt at closing to deliver a debt-free, cash-free company, as was negotiated in the non-binding bid phase when the business deal was cut, we have a gross equity value prior to transaction costs of just over $47 million in this example. And then in terms of the transaction costs, we've run through something that's supposed to, I think, represent roughly proportional expenses. It's not meant to really provide an estimate of transaction costs per se, but I think it gives you a pretty decent ballpark. In terms of the financial advisory fees, in this particular case, we're assuming that the financial advisor actually structured an incentive fee in excess of the initial offer of $53 million, and because they were able to get $7 million in excess of the initial offer, they triggered a pretty significant fee. Not out of line with market, but nevertheless, that's what we're assuming in the case facts here. We're assuming as well, because there was heavy private equity involvement in the process, that we had vendor due diligence and tax structuring advice that was included, and those were there primarily to speed along the quality of earnings work that the financial buyers would need to complete in order to secure their financing. So really that was a means to increase the participation in the process and reducing the cost of getting to a binding bid for the parties in the process, which is becoming an increasing trend. Legal fees in this case are estimated at about $500,000, and that's based on counsel having to review markups of multiple share purchase agreements as well as all the preparatory work, and then of course your standard transaction work. So a little bit in excess of what you would see for a one-off exclusive transaction because of the extra work around the additional moving parts on the agreement. And again, that just further illustrates the importance of working with a law firm that's got the bench strength to deal with 6 markups of 150-page agreements and get through them in a reasonable amount of time and provide some good advice around how to respond. And then in terms of just using Robin's examples, rep and warranty insurance right down the middle of the fairway at about 3% of the insured amount. So in this particular case, with that 20% cap on the indemnity, so an insured value of $12 million, we've got $360,000 in rep and warranty insurance, and then other transaction costs, which would include your BDR and other ancillary costs, including travel and what have you. So in this particular case, we've got a net transaction proceeds pre-tax of $45 million. So with that, I'm going to turn this over to Jake because we did promise to talk about some other recent developments on the legal side from the perspective of the financial advisor. So Jake's going to touch on a couple of those.
Sure, and we're close to wrapping up, so I won't take too long with these points, but as Paris points out, we wanted to give you some of the more recent developments in M&A so that you are aware of the trends. You may have heard some degree of data about them, and now you'll get a more extensive discussion. The first development I want to talk about is legal project management and legal Lean Sigma. So for any of you, both in your own practices and in your clients' practices, you'll be aware of project management as a concept and Lean Sigma as a concept. What we're seeing now is in the legal industry a real push to embrace and adopt these practices and best practices, principles, and so on to ensure that you've got as an efficient a process as possible that is managed according to project management principles. So by way of example, in legal project management, no different than you would imagine, it's a focus on process improvement. We'll talk about that in the next slide. And it's ensuring that lawyers are using the best process for the given task at hand and that you're actively managing the schedules, staff, and deliverables. So Paris earlier in the piece had a couple of Gantt charts up there. It would be really using those would be a kind of a first base in terms of the deployment of these principles, but really ensuring that there's as little in the way of waste and so on, and that you're actively managing schedules so that people are coordinated on steps in the process. Legal Lean Sigma is similar in that it's the same realm, but really here you're looking for and you want to eliminate any waste to create simpler, faster processes. So this is where you really understand the relationships between inputs and outputs. And legal Lean Sigma, like Lean Sigma, which of course was created in manufacturing and speaks to the amount of errors per certain data point of a process, legal Lean Sigma is most appropriate for processes that are repetitive, routine, and require a high degree of accuracy. So for example, document review. So that's an area where increasingly you see an outsourcing of document review in the data and due diligence context, because you can give it to a lower cost provider who doesn't have the high lease costs, for example, of a Bay Street law firm. It can be affiliated with that law firm. It could just be in a lower cost area, or it could be, frankly, these days, from someone's home. So employing and deploying both of these principles is very important. I am certified in both legal project management and legal Lean Sigma, and what that means is I'm looking on every deal to see how we can do things better and more efficiently. Leads me to my next slide, which is the first page of a matter planning and budgeting tool for an M&A transaction that I have used. And what this simply means is you sit down with your client, you sit down with the evaluator, the advisor, the accountant at the outset of a deal, and you say, okay, we're talking on a non-billable basis here. How do we get a sense of what the timing and cost will be for this transaction? Let's talk, for example, about where the operations of, in our example, Pegasus are located. Are there only Canadian operations, or is there a U.S. office? Are there manufacturers in China, for example? Are they owned by Pegasus, or are they just under contract? This type of discussion, this type of analysis will help us understand the best way to manage this deal and the best way to make sure the processes are efficient, and also helps us give the client a fee estimate and, if necessary, talk about alternative fee arrangements, for example. Last piece of other recent developments. One thing we're seeing is that the seller's market continues. What this means is that strategic buyers, for example, are becoming more aggressive. As you heard from Robin, we are finding out that sellers are saying to private equity buyers, you need to have your rep and warranty insurance basically stapled to your bid package, otherwise we won't even look at you. So that's one way in which you can play the game, so to speak, in a strong seller's market. A second recent development would be the vendor due diligence piece. Paris has discussed that. We can answer any questions you have about it, but I won't spend any more time on it than that. Another development we're seeing is the increased use of auctions. We're seeing this, which was primarily, Paris, I think it's fair to say, a U.S. practice, now coming more to Canada, and you're seeing it more in the middle market. I think it's fair to say.
Yeah, I think what used to happen quite often is that a suitor approaches a private company, they sit down and they cut a deal, or they enter into some kind of a discussion, and 8 times out of 10 they don't cut a deal and they break it off. But there is no, in the past there's really been no process. But what's been happening, particularly in the States, and we're starting to see that happen here in Canada as well, is that business owners are becoming very well self-educated on what their alternatives are when they get an approach, and they understand that when they get a call from a potential suitor, that there's an appropriate sort of checklist to run through in terms of the way that they assess that approach. So people are business owners are getting a lot smarter about responding to those one-off approaches. And in fact, in the States, when we talk to private equity buyers, they basically say there's no such thing as a proprietary deal for a sizable business anymore, because even if they are the first to approach a particular company, what happens more often than not is as the sale discussions start to get serious, that owner tends to hire an advisor and start some form of a structured process.
Great. And it underlines that concept that it is still very much a seller's market. And as a result, and along with the educated nature of sellers generally, they are controlling the process more than ever. One question Paris wanted me to address is whether or not agreements are getting simpler or more complex. And, it's tough to say. It depends on the size of the deal, the complexity of the deal. The one thing I will say is that sophisticated deal counsel will address in your purchase agreement, especially on the buyer side, of course, because it's the buyer who typically drafts the purchase agreement, or if it's in an auction situation, they will put in these provisions in the draft PSA that's in the data room. But it's important that your counsel address recent material developments in the law. So, for example, privacy and now CASL, these are reps and warranties you definitely want in there from the vendor. Anti-corruption, anti-corruption in Canada, although the legislation's been on the books for years, has only in the past few years received a governmental endorsement as a priority area. So you're now seeing and should see reps and warranties around any corruption legislation compliance in your purchase agreements. Cybersecurity, which is one that Robin mentioned, is another one that should be in there. So all of this is to say that these reps and warranties are going in on top of the ones you've already got from 20, 30 years of case law and precedent development, and therefore, in this sense, they are getting longer. More asset deals or share deals, we've talked about that. I'm seeing more share deals, and again, as a seller's market, I think that is the underlying reason. And finally, as a U.S. trend, and we've seen this in the data as well, and also as a result of the seller's market, we are seeing a reduction in indemnity caps, escrow amounts, and survival period, in part because, as Robin very helpfully pointed out, rep and warranty insurance can serve to fill a number of deal gaps and to get a deal done, whereas maybe before that deal didn't get done. So now it's done with a lower indemnity cap and or escrow amount. But all of which is to say, all of the things we've talked about today interact with each other. Before I turn it over to Paris for last words, just wanted to reiterate we're available for any questions you may have, and it's been a pleasure speaking with you today.
Thanks, Jake. I'm just going to wrap it up really quickly here. And I see we've done such a thorough job of explaining this that we have no questions. So, so that's great. So in terms of the closing remarks, I've maybe phrased it just slightly differently than what we have on the page, and it's really just to emphasize that what we really wanted to have you take away from this session today is get a pretty keen sense of the areas that as a financial advisor you want to pay special attention to when you start to hand the deal off to the lawyers, and particularly when you start to hear your client say things like, I want all my money at close, I do not want an escrow, that's a non-starter for me. Well, before that would have been the type of issue that might determine whether or not you could take that person on as a client and take their company to market. Well, at this stage, you've got some financial innovations like rep and warranty insurance that can add some additional tools or in your toolkit as the advisor to help you get the deal done and help to close some of those negotiation gaps. So with that, I'd like to thank all of you for joining us this afternoon. And we certainly do welcome any questions if questions occur to any of you, and we're happy to stay on the line a little bit post the 2 o'clock allotted time to answer any questions you might have.
Well, thank you very much. You guys did an excellent job on wrapping up this webinar by 2 p.m. So I'd like to thank very much Paris Aden, Jake Bullen, and Robin Weber for such a comprehensive webinar. And I'm sure the attendees appreciated your perspectives and expertise today. as I had stated earlier during the opening announcements, I will be sending a PDF of this presentation to all attendees in the next few minutes. And I would like to thank everyone who attended and encourage you to visit CICBV's website for a list of upcoming activities for the remainder of the year and into the early 2016 calendar. So I don't see any questions coming in, so in the interest of wrapping this up and letting everyone get back to their jobs, I just want to thank Paris, Jake, and Robin again for their time and expertise today. Thanks very much, everyone.